I am the program director for the Toronto Bail Program and also the co-chair of the West Toronto HSJCC group and the co-chair for the Toronto Regional HSJCC group. We'll start with the land acknowledgement. Is there anybody here that has a special land acknowledgement that they would like to share? Okay, then I am going to do the land acknowledgement. This is something that seemed quite special to me when I read it for the first time. But reconciliation is about establishing and maintaining a mutual, respectful relationship between Aboriginal and non-Aboriginal people in Canada. For that to happen, there must be awareness of the past. All of us must listen, self-reflect on how we are situated in that history, and work to understand and acknowledge the history from Indigenous perspectives. As a white settler, I want to acknowledge the land we are meeting on today is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat people, and is now home to many diverse First Nations, Inuit, and Métis. I also acknowledge that Toronto is covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaty, signed with multiple Mississaugas and Chippewa bands. Toronto is the territory subject to the Dish with One Spoon, Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. Indigenous nations and people, Europeans and all newcomers are invited to join in this treaty in the spirit of peace, friendship, and respect. So welcome again to the HSJCC Lunch and Learn on the Toronto Gladue Court, current services and ideas for future. The mandate of the Toronto Regional and Local HSJCCs is to engage in cross-sectoral planning, coordination, and integration of services for individuals with complex human needs. We've got 4 locals. There's the West Toronto and the North York local that have recently joined together, the downtown local and the Scarborough local. The locals are responsible for identifying issues within their local and service gaps, and then bringing those issues up to the Toronto Regional HSJCC for systems planning and resolution at a regional and provincial level. If you are from Toronto and you're interested in joining the HSJCC, you can put a little blurb in the chat and our coordinator, Domenica, will reach out to you. So we are so fortunate today to have Jasmyn Galley and Emily Hill here to speak about the Toronto Gladue Court. Jasmyn Galley is a member of the Wiikwemkoong Unceded Territory. She lived in England with her parents and younger sister until she was 18 before moving to Toronto to reconnect with her cultural roots and her Anishinaabe family on Manitoulin Island and throughout Ontario. Jasmyn has both an undergraduate and master's degree in English from the University of Toronto. She began working at Aboriginal Legal Services in 2018 as a Gladue Caseworker and has been working as a Gladue Writer since 2021. Jasmyn is passionate about social justice and raising awareness of systemic inequalities. She believes the stories we share have the power to make lasting societal change. Then we have Emily Hill, a senior staff lawyer and court worker manager at Aboriginal Legal Services in Toronto. Emily clerked with the Ontario Superior Court and worked as a legal aid staff lawyer in Whitehorse, Yukon. Since joining ALS in 2011, she appeared at administrative hearings, coroner's inquests, the Superior Court of Justice, the Ontario Court of Appeal, and the Supreme Court of Canada. In 2021, Emily took a leave from ALS to work as a senior commissioner counsel with the Mass Casualty Commission, a joint public inquiry created to examine Canada's largest mass shooting, which occurred in Nova Scotia in April of 2020. So Jasmyn, Emily, welcome. Thank you for being here, and take it away.
Thank you so much. It's nice to be here and nice to be speaking with this audience. Jasmyn and I did prepare a slide deck, and so we'll go through that. But we hope that there'll be time at the end for questions. So I will try now to share my screen, and you can let me know if I have been successful. Can you all see my screen? Okay. So just an overview of what we are hoping to go through today. We'll start with just a high-level overview of Gladue Court, and I recognize there may be people on this call who are very familiar with Gladue Court, may work in Gladue Courts, but we just thought we would start from the basics in case there are people who aren't familiar. Then Jasmyn will get into some more detail about Aboriginal Legal Services, Gladue Services. Then I'll touch on some of the other programs that we run. And then share a recent needs assessment that was done of the Gladue Court and share those results. And then, as I mentioned, have time for questions. So to start with Gladue Court, it's sort of, we need to start back at the very beginning, and the land acknowledgement, I think, was a good way to sort of set the tone for that. The context for Gladue Court and how we got here starts in the context of colonialism. And I think it's important, again, there may be people on this call who are very familiar with Canada's history and know a great deal. But if you went through the public school system like I did in Canada, I didn't learn this history. And again, there may be people on the call who are younger than me and had the benefit of some changes arising from things like the TRC. But it's important that we don't just start the story with Gladue Court in Toronto in 2026, but that we go back to sort of the experiences of Indigenous people in Canada pre-contact and then post-contact, and acknowledge that the process of colonialism has what it looked like specifically in Canada, settler colonialism, and the extreme loss of land. The communities lost 98% of their original lands. The imposition of the Indian Act that is still in place today, controlling who is in and out of community, where at its height in terms of the control that it had. The Indian Act outlawed cultural practices, controlled who could live on and off reserve, who could leave on and off reserve. Some of those pieces of the Indian Act have obviously been set aside, but some of it continues today and continues to have an impact on Indigenous people living in urban environments as well as in home communities. Obviously, the legacy, the ongoing legacy of residential school. Everyone who is Indigenous had family members in residential school. Some people are survivors today in our communities that we work in, and others are the children and grandchildren who survived the impact of that colonial project. The ongoing involvement of child welfare. We talk about the 60s scoop, but that impact is continuing. And the continuing inequities in terms of Indigenous people's access to land, to political power, to educational leadership, all of the sort of pieces of Canadian society and the sort of unequal access to space, to practice the legal traditions, the educational traditions, the political traditions, all of the practices that were in place were thriving before colonialism that have been stripped away, and that Indigenous communities should be credited with preserving and expanding. And so it's against that backdrop that we consider the Canadian legal system in its current form and what steps can be taken now to address and acknowledge that harm. The piece of it that I want to talk about today, and obviously this experience of colonialism needs to be looked at through lots of different lenses, but I want to just speak about it in the context of the courts and the correctional system. And again, these may be statistics that you're well familiar with. I think most Canadians are aware of the overrepresentation of Indigenous people in correctional settings. At Aboriginal Legal Services, we've stopped using the phrase overrepresentation because it doesn't capture the reality. And so the term we use is mass incarceration. The statistics on this screen show that in 2017 2017 and 2018 Statistics Canada report showed that 30% of admissions into provincial and territorial custody and 29% of admissions to federal custody are made up of Indigenous people, First Nation, Métis, and Inuit people, although those communities only make up 4% of the Canadian adult population. And that disproportionality is worse for youth. The Youth Criminal Justice Act was effective in reducing incarceration rates for young people, except for Indigenous people. That continues, Indigenous young people to continue to be well overrepresented. It's also worse for women, both in the provincial and in the federal system. In the federal system, Indigenous women make up half of the population, again, despite making up that less than 4% of the population. And the last statistic is a new statistic that has come out through Statistics Canada, trying to better understand overrepresentation and mass incarceration and how it looks different across the country. And so the number nationally is that the overrepresentation index is 8.9%. So Indigenous people are almost 9 times more likely to be in custody as a non-Indigenous person. And so again, that piece of the context for the legacy of colonialism, what it looks like in our justice system, feeds into why we're here today talking about Gladue courts. So that crisis that we're talking about was first documented, it was documented in a number of national reports, including the Royal Commission on Aboriginal People. And so the numbers have gotten worse, but they were a real problem even leading up to 1996. And so the government enacted criminal code changes, a number of changes aimed at changing how sentencing was done in this country. And the one that we want to sort of specifically talk about today is an amendment to Section 718.2E of the Criminal Code. Again, those of you who are very familiar with the criminal code, those of you who are lawyers, paralegals, or work in the system will know this section. For those of you who aren't, the criminal code sets out guidelines for how judges are to sentence individuals and what factors they should take into account. And essentially, in this section, the government was responding to the crisis of overrepresentation, as it was termed then, and directed judges to consider all available sanctions other than imprisonment that are reasonable and should pay particular attention to the circumstances of Aboriginal offenders. And so it's that section of the criminal code, which is still in place today, that gave rise to the court case Gladue, which is why we call Gladue courts Gladue, because this court case called Gladue. And I'll put it up on the screen. I won't read this all to you, and I don't expect you to read it all. Again, those of you who are familiar with the case will know these passages. But this is what the Supreme Court said in 1999 in response to the question that came before the court, which was, how should that section of the criminal code be interpreted? What does it mean? And for the case of Jasmyn Galley, who was the woman who was being sentenced, in this case, the Supreme Court considered and gave direction to courts across the country. And I think what's important in this quote is the finding of the Royal Commission on Aboriginal People that's endorsed by the Supreme Court, that says that the criminal justice system has failed Aboriginal people of Canada. It's really strong language, failed First Nation, Inuit, and Métis people on reserve, off reserve, urban and rural, and in all jurisdictions. And explains that the crushing reason for this crushing failure is the fundamentally different worldviews of Aboriginal and non-Aboriginal people with respect to elemental issues, including justice. And so that's really important when we think about the reasons for this overrepresentation and how we got here. It's complicated, and there are a lot of reasons, but for those of us who work in the justice sector, the Supreme Court has said in 1999, and they have said it repeatedly in cases that followed it, that the reason for overrepresentation, or a significant reason for overrepresentation and mass incarceration, is the failure of the justice system to account for these different worldviews, as well as discrimination that is embedded within the system itself. And so the courts discuss in this passage, the Supreme Court says that those findings cry out for recognition of the magnitude and gravity of the problem. And so that is sort of what the case of Gladue is about. And so that leads to the question of, well, how? What are judges supposed to do? If they're aware of this mass incarceration, they're aware that it arises from the failure of the legal system and the different worldviews that are clashing in our justice system, where the European or the British common law system is imposed on Indigenous people, not taking account of the fact that they have their own legal orders and legal systems to resolve disputes in their communities. What's a judge to do with that? And Gladue said there's two things. One is judges have to consider the unique systemic or background factors which may have played a part in bringing the particular Aboriginal offender before the courts. And they need to think about sentencing procedures and sanctions which may be appropriate in the circumstances. So if you think about the role that the judge has to think about background factors, understand the person in front of them and how their experiences as an Indigenous person are relevant to their sentencing, and what sentencing or sentencing processes might be appropriate. If you keep those things in your mind, I think you'll understand, as Jasmyn explains, a lot of the work that she and her team do in the Gladue context. And I should say that while I use the term judges, Gladue has been found to be applicable in a lot of other settings. So in the review board that governs people who've been found not criminally responsible, in extradition hearings, in bail proceedings where JPs are often, justices of the peace are often presiding. There's a lot of different settings where these principles that arise from Gladue and arise from the criminal code have been found to be applicable. And so the story of Toronto's Gladue Court, and there are Gladue courts right across the country, starts in 2001, where a Gladue court was opened at Old City Hall. And eventually these specialized courts were opened across all of the courts in the city, including the youth court at 311 Jarvis. And as you know, if you work in Toronto and in the justice system, the amalgamation of all of those courts to 10 Armory was a huge undertaking. And so the new courthouse opened in 2023. And as part of the planning for that court, our office was involved in discussions about how should we create the Gladue court and take what we've learned in the Gladue courts that have happened in all the different courthouses in the city and apply it at 10 Armory. So I can talk a little bit more about what 10 Armory looks like and how it operates now, but I think I'm going to hand it over to Jasmyn to talk a little bit about the services that ALS provides in Gladue courts in Toronto, but also in other places in the province. I will just say that Gladue courts are sometimes also called IPCs or Indigenous Peoples Courts. And there is some discussion about whether that's a more appropriate name for the courts. So we've been using the term Gladue court, but I just wanted to put that on people's radar or acknowledge it if they've sort of found themselves in those discussions. I'll hand it over to you, Jasmyn.
Thank you, Emily. Just setting up my stopwatch here so I don't overrun too much. Okay, hi everyone. Thank you for being here today. As you may have heard at the beginning, or if you're just joining, my name is Jasmyn and I've worked as a Gladue Caseworker and a Gladue Writer at Aboriginal Legal Services in the last 8 years. And as was mentioned in the introduction, I'm a member of Wiki, which is an Anishinaabe First Nation on Manitoulin Island. But I grew up in England, and I can tell you that my accent almost always throws people off. It's definitely a source of conversation with clients. So today I'm going to be talking about the Gladue services ALS offers, specifically the types of documents we prepare, the writing process, and how our Gladue documents are used in various settings. So some of you may be very familiar with this process, in which case I apologize. And for others, what I'm about to talk about might be slightly familiar or even brand new. I will be doing a bit of a deep dive, which hopefully will provide more context into Gladue itself, as well as its impacts on the individuals we work with and their communities. Emily, if you could please take us to the next slide. Did it move?
Working on that.
Okay.
There you go.
There we go. Okay, so what is the purpose of Gladue reports and letters? Generally, they are to outline the client's personal, family, and community history with attention to systemic and historic factors that are specific to being an Indigenous person. The intent is to reduce custodial sentences and reduce the number of Indigenous offenders in custody, as well as provide culturally appropriate and holistic healing opportunities. So because of that, reports and letters will present appropriate recommendations for the court to consider in sentencing instead of a custodial sentence. Next slide, please, Emily. I'm now going to briefly talk about the difference between reports and letters, and this is specific to Aboriginal Legal Services. We offer two types of documents for clients who are going through the judicial system, Gladue reports and Gladue letters. And the Crown's position determines which document the client will receive. So reports are prepared when the Crown is seeking more than 3 months of custody, while letters are prepared when the position is less than 3 months. And this distinction usually hinges on the severity of the client's charges, and it determines the length and depth of the document that we will prepare. Gladue reports are the longer of the two, and they can be up to 50 double-spaced pages, while Gladue letters average around 10 to 15. Both will focus on the systemic and historic factors, and you'll hear me say that phrase a few times throughout this presentation, that have contributed to the client's involvement with the justice system. And both reports and letters, as I've mentioned, include individualized and, where appropriate, culturally grounded recommendations for the court to consider in sentencing. So as you can see here, the difference between the two, oh, Emily, you can go back to that one just so everyone can read it. The difference between the two documents that we prepare is largely one of depth. ALS's Gladue letters are higher level documents that focus more on a client's current circumstances with a briefer summary of those background factors, whereas Gladue reports provide a deep dive into what led the client to where they are today and often include interviews from several family members or other supports to discuss their personal history, as well as even the family and community histories. So as such, there are different timeframes for each document. With the Gladue report, we get 6 to 8 weeks, and with the Gladue letters, we get 4 to 6 weeks. And this includes the time it takes to connect with the client, schedule interviews, including with the client and supports, and the final internal editing process at Aboriginal Legal Services that each document goes through before it's considered court ready. So I just wanted to point out, while 1 or 2 months does sound like it's plenty of time to prepare a Gladue report or letter, it sometimes can feel like it's not enough. Clients who are out of custody can be difficult to reach, either because they're working, they might be engaged in programming. Some of them might even be avoidant and hesitant to start the process. And those who are in custody may be inaccessible due to things like lockdowns and even being moved from one institution to another without anyone's knowledge. I've actually had to find out where my clients are before, when I thought they were at one institution and they got switched. So coordinating interviews can take time. Not to mention that the process itself is delicate and can be re-traumatizing. Our clients are often asked to revisit and discuss the most painful parts of their lives, and it's sometimes for the first time. So building that trust and rapport, it does take time. I've had interviews that have lasted several hours over several weeks before a client has finally shared with me something that's essential to their story. And then add to this that we have several files on the go at once, so you get the picture. However, and before we move on, I will say we do our best to avoid requesting adjournments. This is because courts sometimes proceed without a Gladue document, and obviously any delays in preparing them can result in clients spending more time in custody than is necessary, which is obviously something we don't want, especially if they're already in a position of time served. Okay, next slide, please, Emily. So these are our Gladue roles at ALS. As you can see, we have quite a robust Gladue team, which ranges from Gladue coordinators who assist with assigning files to our Gladue program specialist, who edits the Gladue reports. I do not envy that job. And the two main roles that I will discuss here today are obviously going to be the distinctions between ALS's caseworkers and writers. So that's at the top of the slide. You can see both roles do involve writing and interviewing, but the Gladue writer's role is focused entirely on report preparation due to the length of those documents, whereas Gladue caseworkers, in addition to writing letters, also provide aftercare services. So because of this, Gladue caseworkers will attend court dates, they support clients in following through on recommendations, and they'll connect them with community resources and support to help with their healing and reintegration. So, for example, this can look even something like accompanying a client to an appointment for the first time. When a client receives a Gladue report, they'll work solely with a Gladue writer up until their sentencing date. And then once that date arrives, the writer's job is finished and the file is sort of handed off to the caseworker. So then they pick up the file to ensure the client has access to and direction to those aftercare services that have been outlined in the report. However, if a client has been assigned a Gladue letter, they'll be working with a caseworker throughout the process. So they'll work with them as the letter is being prepared, and then they'll stay connected to the caseworker for the aftercare component as well. I should mention that not every client does immediately get assigned a caseworker. So when we have clients who are looking at, a significant amount of time in custody, usually because of the severity of their charges where there's a mandatory minimum, we will recommend that they contact Aboriginal Legal Services closer to their release date, and then they can liaise with our Gladue liaison worker and speak with them to get assigned to an aftercare worker. One more thing I want to mention about the caseworker role is, so caseworkers are obviously responsible for managing a roster of clients, but a client's involvement with a caseworker is voluntary. So the caseworker will make an effort to connect with them after their court date, providing their contact information and checking in with them occasionally. However, caseworkers do not act like probation officers, and this is something I always share with my clients that I'm working with. So the client is free to utilize our caseworkers' services as much or as little as they like. And this allows caseworkers to obviously prioritize clients who want or need more support, as well as respect the autonomy of clients who are already connected to services or working with another organization so that we don't overwhelm them. Okay, next slide, please. Thank you, Emily. So talk a little bit now about the writing process. This is different across every organization, but at ALS, we kind of have, I guess, a certain flow once a file is assigned. So the first thing we all do, writers and caseworkers alike, is an intake interview with the client, usually lasting about 20 or 30 minutes. And this is to outline the Gladue process, set expectations, and determine the client's Indigenous ancestry. Now, this part is important because, as many of you may know, across many sectors in Canada, and it seems to be like more in recent years, we are seeing individuals with questionable or dubious claims to Indigenous ancestry accessing services and spaces that are not theirs to claim. And unfortunately, Gladue is no exception. So a critical part of our work is ensuring that our Gladue services are provided to those that they are intended for, but we also have to remain sensitive and aware of the historic issues that may have led to displacement from their community and loss of cultural connection. I mean, me, for example, growing up in England, I have a British accent and I definitely didn't grow up going to ceremony. So in this way, determining ancestry exists on a spectrum from clients who are Indigenous but know very little due to those factors I've mentioned, such as forced adoption, maybe growing up off reserve, family members who refuse to share their stories, either because of their experiences or because of, an internal shame about being Indigenous. Sometimes they even outright deny their ancestry. And then that spectrum continues to clients whose claims are based on family myths with little to no supporting evidence. And as someone who works in Toronto, I can say probably 1 in 2 of my files fall into that grey area where the ancestry can't be determined. So in those cases, Aboriginal Legal Services cannot prepare a Gladue report or letter because, while we are meeting with an individual who has their own unique circumstances, we can't connect those experiences to Indigenous specific systemic factors that have led them to appear before the court. So for example, how can I talk about history of Indian residential school attendance if nobody actually attended? So focusing on ancestry in this intake interview usually involves asking questions such as, which First Nation or community is your family connected to? Does anyone have their Indian status? Have you ever spent time on a reserve? And can you share the experiences of Indigenous family members with me? Often within sometimes even 5 minutes, but I'm going to be generous and say 20, it's very clear whether we can proceed with writing a Gladue report or letter for that person. And as you see at the bottom of this slide here, verifying ancestry can be as simple as calling a band office to confirm the person is registered or speaking with a family member who is. But in more complex cases where that person maybe doesn't have a family member I can speak to, doesn't know which community they're connected to, we can do a little bit more digging. So recently, ALS has actually started doing more genealogical research for this purpose. And I'm quite adept now at tracing family lineage through like the Canadian censuses, for example. And I found that can make things very clear cut. I cannot prepare a Gladue report for someone whose grandparents are listed as Irish immigrants on one side and English on the other, for example. So next slide, please, Emily. So in cases where Indigenous ancestry can't be confirmed, ALS will prepare what is referred to as a no Gladue report or a no Gladue letter. And in this document, we'll outline what the client shared with us, the research that we did on our end, and what was found. Now, crucially, and we put this into every document, just because we cannot discuss how being Indigenous has impacted that person, it does not mean they're not Indigenous, and it does not mean the lawyer cannot bring up Gladue factors in that person's case. It just means that we don't have enough information to prepare a fulsome document specific to those experiences. And the no Gladue process ultimately protects Indigenous clients, as well as Indigenous spaces and services, such as housing resources, for example, which can be and often are at capacity or underfunded. All right, I hope I'm not going too fast. I'm a little bit nervous. I never do presentations, so my apologies. Right. Next slide, please, Emily. Okay, so now I'm going to talk a little bit about the content of Gladue reports and letters. Once we have determined that we can proceed with like a Gladue document for a client, the interview process begins in earnest. So as mentioned, it takes 4 to 6 weeks for letters and 6 to 8 weeks for reports. And caseworkers and writers are juggling multiple files at a time. Interviews can take place over the phone, they can take place in custody, and they can include family members, friends, or community, or even health support workers. So broadly, to start, Gladue reports and letters will lay out those historic and systemic factors that have impacted the client intergenerationally. And I do want to call attention to the fact that experiences differ greatly between everyone, even though they might share like overarching factors. So for example, individuals who've been raised on reserve versus those who've lived in urban settings. So on reserve clients, we might discuss how their communities have been impacted by Canada's resource extraction or by their remoteness, and how that impacts their access to services or how expensive food is on the reserve, and whether, as a result, they continue to engage in cultural practices such as hunting and trapping. Obviously, our documents examine the impacts of the residential and day school systems on families and communities. My grandmother was an Indian residential school survivor, but often I think people forget how recent this history was. The last Indian residential school to close in Canada was in the mid-1990s, I think 1996. Sorry if I'm wrong by a few years. And I have clients who are my age who've attended an Indian day school during their childhood. So that history is really not as far behind us as some would like to believe. And in those cases, what the report or letter is talking about is, you know, the personal, generational, and community impacts of those things. Did that person go on to struggle with their mental health or substance use? Did they lose their connection to their culture or language? Did they remain in the community or leave? How did the community as a whole move forward from those systems? And what issues remain present today? I also personally like trying to bring some positive things into the report. So I'll talk about things like rebuilding culture and resilience in communities as well. So it's not all doom and gloom. So if a client grew up away from their First Nation, I will ask about their experiences in a town or city. Oh, my laptop's trying to update. Go away. Okay, if I drop, it's not my fault. Okay, so if a client grew up in a more urban setting, we may discuss racism, discrimination, and lateral violence. But this does not only occur between Native and non-Native Canadians. Surprisingly, the sort of us versus them dynamic can arise between on and off reserve members. This is another result of colonialism, but may not be as obvious at first glance as something like attending an Indian residential school. However, it does still cause displacement from a community, and it can often contribute to identity struggles and feelings of not really belonging anywhere, which can obviously have negative impacts on a person as they grow up. So, after establishing all of these historical contexts, the report or letter, the letter a little in less detail, but still there. We'll move into the client's personal history and we'll connect all of these systemic factors to the trajectory of their life. The goal being to help the court understand how colonialism has and how it continues to shape our clients' lived experiences, and also what healing might look like going forward. So these factors render each Gladue document unique, despite the overarching shared experiences that stem from Canada's colonial history. Okay, next slide, please, Emily. Okay, so every Gladue document ends, or Gladue letters and reports ends with recommendations for the court to consider in sentencing. Sometimes these are very straightforward, building on services that the client already knows about or is already accessing, such as going to a friendship center or even applying for a nearby healing lodge. Other times, recommendations can start at a very basic level, such as obtaining ID or connecting with a mental health support in the area. Additionally, due to all the stuff I mentioned before, those systemic factors that our clients have experienced, not all recommendations will be culturally based, and we have to take this into account. So some clients will prefer Western approaches, and that choice is obviously respected. I think it was last year or maybe the year before, a bit of a blur because I feel like I have lots of files, but I did have a client who was actually a pastor, and their entire family was devoutly Catholic, obviously itself a result of like residential schools. So although my client and their family were aware of this history, Catholicism was something that my client truly believes in and has shaped their entire life. And they actively requested that they didn't want to have Indigenous specific recommendations because that actually conflicted with their way of being. So at the end of the day, I always share with my clients that we're in a dialogue during these reports. I might be the one who's interviewing them, asking all these kind of invasive questions and writing their story that's going to be read by the court. But ultimately, we're working together on what we think would be beneficial for them moving forward. So I like to think of the process as always collaborative. I'm not telling a client what's best for them. We're working together to identify these realistic, meaningful goals with the appropriate supports. The idea being that we never push clients into something they're unwilling to do, because that can undermine the whole healing process. And sometimes courts aren't really aware of that. They just want someone to go to treatment. But forcing someone to get clean or sober before they're ready to can sometimes push them in the complete opposite direction. So maybe our focus in that case would be cutting down on harm reduction. I always try and meet clients where they're at, just tell them we're working as a team. And I don't want to act as someone in a position of authority who's assuming that, I know what's best for them. If I did that, I'd be no better than the systems that created the situations Indigenous communities and individuals find themselves in today. And that's not the point of Gladue. The aim is to be holistic and restorative. And importantly, it can be a starting point for healing in that regard. So clients need to walk that path at their own pace. All right. Next slide, please, Emily. Okay, so I wanted to talk a little bit about, Emily has already mentioned how Gladue can be utilized in different situations. So it's used throughout the court process. It can be taken into consideration at bail hearings. In those instances, a court worker or maybe even a Gladue caseworker will provide the court with a plan of care that considers the client's Indigenous background and suggests appropriate resources and programs that they can access out of custody. So as I mentioned earlier, it's the caseworker's role to attend court and provide support to the client when the writing process is over. And that's when community reintegration begins. Oftentimes caseworkers who are being assigned to a client who's had a Gladue report prepared for them will meet them for the very first time at that client's sentencing date. And it's at these sentencings where we really see Gladue letters and reports coming into play. I've attended a fair few sentencings in my time, and it's really clear how these documents humanize the person appearing before the court. Sometimes you can like tangibly see how their character is being reassessed as a result of what's written in the documents we're providing. And as I mentioned earlier, except where mandatory minimums apply, Gladue can result in reduced custody or even community-based sentences. So the recommendations will then be incorporated into probation orders, so probation officers are aware of the available supports to that client in the community. Okay, next slide, please, Emily. I think I've got, yeah, 2 left. So this one and one more. All right, so another way Gladue is utilized is in sentencing circles. At ALS, actually, one of our Gladue managers has started working with members of the court to host pre-sentencing circle meet and greets just to explain the process to everyone, because I don't want to say it's a new way of sentencing, but there's obviously a lot of unfamiliarity with it. So she will set expectations, answer questions, and just like kind of give the outline of what a circle should look like. And I've been present at several circles where it's the judge's first time participating, so they really appreciate that support in like how to guide the proceeding. And sorry if everyone is familiar with sentencing circles, but I thought I would talk about them a little bit. I love a sentencing circle personally, so they break the courtroom down into a more like community setting. Everyone is sitting around in a circle and they're passing around an item that determines when they can speak. In some cases, it will be an eagle feather. I've also seen a braid of sweetgrass being used. And it's not uncommon for sentencing circles to include not only the client and their family and supports, but also individuals and families who have been impacted by their actions. So I've personally been present at some very powerful sentencing circles. I think it was last year in early 2025, I attended one at the 10 Armory Courthouse, and the Crown completely changed their position from several years in custody to time served and probation. It was a very long and emotional day. I think it was like a whole day event, lots of crying. But what makes these sentencing circles so powerful and healing is not only the inclusion of community, but the fact that everyone seated within that circle is coming together to collaborate on how everyone can move forward. So it's that more traditional and holistic form of justice, but it also doesn't mean a client isn't being held accountable for their actions. And when I have a client who's going to have a sentencing circle, I kind of sit down with them beforehand. I'm like, you do realize there's going to be lots of tears, and just kind of prep them for that process. So yeah, in Gladue or Indigenous Peoples Court, there's already access to cultural supports, such as a smudge to open the court proceedings, for example. But there's even more cultural activity within a sentencing circle. It usually opens with a smudge and a prayer from an elder. And the presence of an elder throughout the proceeding provides a grounding yet quite authoritative voice for the client and the community. And as I've mentioned, I've cried at like so many sentencing circles, and it's normally when the elder leading it is giving a teaching either directly to the client or just in general, and then I just start weeping. And I've seen everyone crying. I'm like looking around the circle like who's going to be set off next. So it's very emotional but very healing for all involved. And finally, final slide, please, Emily. Okay, so Emily also mentioned Gladue reports being used in Ontario Review Board hearings. I would say in the last year, I've actually prepared several Gladue reports specifically for these hearings, and that's when a client has been found not criminally responsible for their actions, and they're often under the care of a mental health facility. So in this case, the Gladue report obviously provides that background, but it's more used in going forward to help determine for the client what the supports are or could be available to them if it's decided they can have greater community privileges and can access services outside of the facility. So an example would be maybe they're given, the permission or the freedom to leave the facility once a week to go to a Native Friendship Centre and attend like a men's drumming circle. So I have, I think, 3 or 4 of those types of files on the go at the moment, and I quite enjoy them. They are different, and yeah, always a learning opportunity for me. So I think that summarizes everything. Thank you for listening. I told Emily I'd only be 20 minutes and I overran, so I apologize. I'll be happy to answer any questions anyone has at the end. Okay, thank you. Back to you, Emily.
Thanks, Jasmyn. That was very helpful. And I imagine there may be some questions. So I'm going to talk a little bit about some other services that Aboriginal Legal Services provides. You heard from Jasmyn about the Gladue Caseworkers and Gladue Writers. Also, we have other programs, particularly at 10 Armory Street and also at the TRBC at the Bale Center. We have Aboriginal or Indigenous court workers. That is one of ALS's longest running programs. It's a national program that there are court workers across the country, obviously not run by Aboriginal Legal Services, but many Indigenous agencies and service providers in different courtrooms across the country provide Indigenous court workers. And they're really a vital service for Indigenous people when they're either first coming into the system. It is such an alien process. Such a stressful experience to be going into court for the first time or to be returning to court if you've been there before. And so Indigenous court workers generally, act as both a friendly face and also a system navigator. For ALS, there's also some other important functions that they can play. As Jasmyn mentioned, at bail, if there's a question as to whether or not an individual can get bail, our Indigenous court workers can help with bail plans and help give the court information about services that the client is able to access in the Indigenous community here in Toronto that may help them be able to meet conditions that are going to be imposed on them through bail. Also, they are the people who facilitate our diversion programs. So another long-running program at ALS is the Community Council program, where we have volunteers from the Aboriginal community here in Toronto who volunteer to sit as a council and meet with people who've had matters brought before the court and had them diverted away from the mainstream sort of colonial legal system to a community legal system. So what happens is if someone has charges before the court, if they're interested in diversion, they can speak with the court worker and the court worker will explain the program to them. The individual needs to be able to take responsibility for the charge that they're facing. And ultimately, if it's approved by the Crown, the charge is stayed in the courthouse and by the judge or withdrawn by the Crown. Sorry, I should say withdrawn or stayed by the Crown. The matter is taken out of that courthouse and handed over to ALS. The individual is told, okay, you have a hearing at Aboriginal Legal Services on this date and time. They come and they meet with those volunteers, those community council members who sit with them, talk to them about what happened, and help come up with a plan to address often some of those root causes, what brought them into conflict with the law and what can be done to address it and prevent that from happening again. So the court workers are really the people who have that responsibility to explain the process to community members, explain the process to the Crowns, to defense lawyers, to duty counsel, and to the individuals themselves, and facilitate and support the community council program in the courthouse. The court workers also can answer questions about court processes. They can make referrals, connect people to legal aid and to lawyers. So they can be a really valuable resource. And as I say, they're based right on the 9th floor at 10 Armory. So they're right outside the Gladue Court. They are also available at TRBC and also on the 6th floor, which is where the Indigenous Youth Court is. Jasmyn's already talked about the Gladue reports and aftercare. ALS also runs a victim advocacy program. Those overrepresentation numbers, that experience of being over-incarcerated and over-policed, Indigenous folks are also overrepresented as victims of crime. We know that most sort of top of mind for people may be the missing and murdered Indigenous women inquiry that happened, that's shone a spotlight on that continuation of colonial violence against Indigenous women, girls, and two-spirited people. And so we have a number of people who come to us who have been experienced violence and have become victims either right now, something that's happening in their life right now, or something that happened to them before maybe in one of those institutions, maybe when they were in foster care, maybe when they were in day school. And so they come to us and we can provide support, resources. If people are going through the court process, we have victim support workers who can go with them and support them, because that's a really scary and intimidating thing for a victim to do. Can help with police advocacy, all sorts of services that victims and survivors need as they find their way back to healing and to engagement with the legal system if that's what they want, engagement with the police if that's what they want, or just connection to community services that will help them in their healing journey. We also have Gladue, which is a child welfare program. Again, it's a diversion program. The hope is that families who may be involved in child welfare, be it Native Child and Family Services or one of the other child welfare agencies, can be supported to sit in a circle with elders and other community volunteers to find solutions that will work for their family together, that may be more culturally relevant, more sustainable, more effective, more appropriate for their family and their community than those that may be explored or imposed by courts. It also is available to families who just want to resolve perhaps a civil dispute or having other issues that would benefit from that kind of cultural space and the circle to have some of those really difficult discussions. I know Jasmyn mentioned tears at sentencing circles, and I know that there are certainly often a lot of tears at Gladue circles, but also a lot of laughter. I'm sometimes nearby when those circles are happening, and there's often a lot of strength and resilience and community knowledge and pride that comes out through those processes. We're also a community legal clinic, so we provide, ALS provides in Toronto a lot of the poverty law services that you would see at other legal clinics. So whether that's help with eviction or issues with Ontario Works or Ontario Disability Support Program. We also help people who are trying to navigate the Indian Act and have questions about their status or have been denied status. Those kinds of administrative legal services we also provide here. And then the Aboriginal Legal Services Clinic, our legal clinic, and our lawyers get involved in inquests where we represent families whose loved ones have often died either in police custody or in jails, and represent their families in those legal proceedings. And then we also intervene at courts, often courts of appeal and Supreme Court, but even courts of first instance, where we are trying to actually change the law, make the laws that exist different or better for First Nation, Métis, and Inuit communities. So we do a lot of different things at ALS, a lot of them at 10 Armory, a lot of them here in Toronto, but also some of those services at sites in other places in the south and the near north. So you can find a lot more information about that on our website. Oh, so I wanted to next talk a little bit about this Gladue needs assessment that was done. When the decision was made by the provincial government to amalgamate all of the Toronto courts into one central courthouse, ALS raised some significant concerns with that. We knew that it was going to be difficult for our clients, just geographically, as we all know, and especially on a day like today, getting around the city can be difficult. It's hard for our clients to travel across the city. It's difficult for sureties who may be involved in bail plans, witnesses, victims who are testifying, and community supports, people who want to come out and support their family members. These are all really challenging for people when they have to come to downtown Toronto, whereas before they may have just been able to attend their local community court in Scarborough or in North York. It's also a very intimidating building. I don't know if you've been to 10 Armory. Some of you may work at 10 Armory. It's a bright and shiny building for those of us who are used to walking into courthouses, but it can be a very intimidating space for a lot of our clients. And so as that work was undertaken to move into one courthouse, ALS sat at the table and did some advocacy around what a Gladue court should look like, and also said that there should be some evaluations as we go along to check how things are working. And so just to paint a picture really briefly in terms of what the courthouse, the courtroom looks like in the courthouse, there are Gladue courts on the 9th floor, as I mentioned, right near ALS's offices. There are 2 courts that are sort of set up so that if the judge wishes, they may sit sort of in a circle along with the Crown and defense and other justice participants rather than sitting up on the dais. There is some Indigenous art nearby. There are snacks available. And it is generally a place where we try to make people feel a little bit more comfortable, even though it's often a very uncomfortable setting. We start each day with a smudge, and there's always medicines available, Indigenous medicines available for clients as they come in, if that's something that they want to take part in. And as I say, there's also a youth court on the 6th floor. So that's how things stand now. And so Aboriginal Legal Services hired a contractor to do a needs assessment, and they completed that needs assessment and have been presenting the results of it sort of through 2025. And so I just wanted to share their slide deck with you. So they've prepared the slide deck, but I can just walk you through what they found in their assessment of the current Toronto Gladue Court. You'll hear in this presentation about sort of the questions they asked and what they found was working and not working now, and what their suggestions are for the future. So that is, as I say, this is their slide deck. So the objectives of their assessment was to really see how the new court structure, this amalgamated court, was working for the perspective of Indigenous clients, Gladue court users, and Indigenous community service providers. To look at how the court, the Gladue court at 10 Armory was, how effective it was at implementing Gladue principles and looking at restorative justice options. Look at how ALS is doing its work, and look for opportunities for improvement and expansion of access to justice for First Nations, Inuit, and Métis people who are involved in the court system. So this just sets out a little bit about how the assessors did their work. They interviewed judges, Crown attorneys, staff, duty counsel, people at the Toronto Bail Program, private lawyers, and justices of the peace. They were sort of, many were invited to interview, and you'll see this graph shows who was invited and who was able to participate. This is sort of their findings about the improvements that the new court structure, the Gladue court at 10 Armory, things that are working well. People talked about increased respect and dignity, that the players in the court system and the court itself was a place where they felt there was more respect, humanity, understanding, and compassion. There was a support for culture and for improving safety in the courtrooms. The changes to the courtroom design, the fact that there's Indigenous art, smudging, food and water, and some of the removal of colonial formalities. It's up to the judge who's presiding in Gladue Court exactly how the court runs. It is their court to run, but many of the judges don't require people to stand up when they're speaking, to bow when they're speaking to the judge. The coat of arms is not visible. It is a less formal process, although it is still a respectful space. Because all of the courts are brought together, there is now access to Gladue Court 5 days a week. When the courts were in different parts of the city, most courthouses had 1 or 2 days a week of Gladue services, whereas at 10 Armory, there are Gladue courts every day of the week. And clients feel that the new Toronto courthouse's Gladue courtrooms are run more efficiently compared to other experiences they may have had in other courtrooms and in other courthouses. The concerns that were raised by people who were interviewed were an inconsistency of Gladue teams. Gladue courts work best, and we have found this from our very long-running courts at Old City Hall and at College Park, when there's a set of experienced judges, duty counsel, and crowns working together who know each other and know the clients that they're working with. The location of the court was flagged as an issue, that people who are trying to get downtown, there may be barriers in terms of accessing services, those who face transportation barriers, especially for people who live outside of the downtown core. And that a lot of what's being done day to day in the Gladue Court may be working well, but it's not very formal. There's not a lot of structure to it. And so that means it relies on the participants to really show up every day and do this good work, whether it's the judges or the crowns, duty councils, to sort of show up and follow the procedures and practices. But any of us who've worked in organizations who have those sorts of informal structures know that when someone leaves or someone goes on vacation or someone has a baby, sometimes those things can fall away. And that was identified as a risk through this assessment process. I think this is my favorite slide from this presentation. It just says verbatim what the assessors heard from Indigenous clients who were going through the courts, and reflects their experiences. I'll just read out a few of them. I know you can read them, but it says it's still nerve-wracking, but the layout is better. It's nice to see people from the street get food and feel like I'm being treated with respect. It's nice to have snacks. People don't always have food, and that's true even for people who are being brought in custody. They often, they leave the jail that they're being held at, like at 5 a.m, and they're put in a van and they're brought down to the court. They will sometimes, as we understand it, like get one sandwich for the whole day. They're hungry when they arrive, and they're having really important conversations about things that can really affect their future. And just in the way that we talk about how children in school can't learn if they're hungry, people in court can't focus if they're hungry. I've been in court when I'm hungry, and I know I can't focus. So just attending to those really basic needs and treating people very respectfully is so important. And it's something that doesn't happen in our courts enough. And we really try to do that differently at the Gladue court. And then the comment about it smelling like sweetgrass. The opportunity to have smudge is something that many people don't have, either in their own homes, maybe in the shelter that they're staying at, in the jail that they're being held at. So the opportunity to access that cultural practice can make a real difference. This is the voices of people who use the Gladue courts. So this may be, staff and others who are in and out of the Gladue court. And you'll see that a stress around relationships and building relationships. The shout out to the ALS court workers, saying that they go above and beyond to ensure clients understand their rights, assist with court appearances, and set up necessary diversions or hearings. And again, the echoing concern there at the bottom, that the concern with the consolidation was always the location of the New Toronto Courthouse, and access and transportation being an issue for clients, for their families, for their sureties, and to be able to get to hearings. So I think it's important to have these concerns documented so we can sort of take account of it and try to think of ways we can address what we can. Again, more voices from people who use Gladue Court. The area itself can be intimidating. Many people we serve feel vulnerable around authority and police. It can feel like an overly daunting area to be in such a busy area when there's so much going on. People are used to having a neighborhood courthouse. It's a bit of an issue because some people don't want to come downtown for various reasons, but they have to in order to benefit from the Gladue system for the most part. And I think that's something I've certainly heard from clients, that especially if they're trying to make different choices in their life, stay away from certain places and certain people, it can be hard to ask them to come to downtown Toronto, come to a busy courthouse where, there's a lot going on and there's a lot of people around. This emerging issue that was flagged by the assessors, the self-identification in the court system. As Jasmyn talked about, there's a lot of individuals who grew up in Indigenous families who were told not to identify themselves as Indigenous, not to reveal that they were a First Nations person, being told different stories about themselves, or who grew up in foster care or adopted homes where that piece of themselves was either actively or passively put to the side. And so many Indigenous clients do not self-identify early enough in the process and may fall through the cracks. They don't know to speak up and explain that they're Indigenous. They don't know that that may be of a benefit. They may quite rightly be concerned about being discriminated against. As I mentioned in Gladue and in many court cases since, the Supreme Court has said we have a discriminatory system. And so people may be quite right to worry that they're going to be singled out and be subject to racism if they speak up and say that they're Indigenous. But that makes it hard for those of us who want to make sure that they're accessing the processes that are uniquely available to Indigenous people in the court system are available. Similarly, the police divisions that are processing people and maybe sort of taking people in and giving them a court date, they may not know that that person is Indigenous, or they may themselves not be familiar with the services that are available and may not flag that to the person themselves, that the Gladue Court is an option for them. And there may be just a lack of awareness about how to access Gladue services, or that they're even available. All the changes in the court structure itself, the geography, COVID, things being hybrid, it's hard. It's a hard system to navigate, and so that's especially hard if you're dealing with all kinds of other issues as well. Another issue that has come up for particularly Indigenous community service providers is that one that was flagged by Jasmyn, which is that people, again, perceive that Gladue Court is going to bring them a benefit, whether or not they are Indigenous, whether or not they've had those sort of those colonial processes, or the legacy of those colonial processes impact them as an individual. And so people may be coming to Gladue Court who are not in fact First Nation, Métis, or Inuit. And so that's an issue that we have to sort of begin to have conversations about how we sort out. I think it's really important to flag here that Gladue Court is a court run in the Ontario criminal justice system. Aboriginal Legal Services does not run the Gladue Court, just as in Jasmyn's explanation that when they write a letter saying, we can't write a letter for you, they don't say you're not Indigenous. And similarly, it is not for ALS to determine who can and cannot be in Gladue Court. We don't decide that. It's not our court. It is Toronto's court. It is Ontario's court. We provide services there. But this question of, who should be there and who should not be there is not ours alone to solve. And so it's important that we have conversations with all system actors to make sure that those who would benefit from the process and who the section of the criminal code and the Gladue jurisprudence is aimed at receive that benefit, and that those who it's not aimed at are not taking up space and resources. Again, and this is probably something that most of you on this call will know, but those individuals also have a right to have their story understood, to have their unique experiences understood. A sentencing judge has a responsibility to take into account to hear from the person and hear about the person who they're being sentenced as and understand their particular journey. So it's not as if those factors don't exist outside the Gladue Court, but the focus in Gladue Court is on Indigenous people, and so that's who should be in that court. These are some options to continue to move toward access to justice that were identified in this report. One is about hybrid options. We're trying to figure this out, like all of us, across many different systems post-COVID. How can we have hybrid systems that work well for people? For example, youth who are in school, should they have to spend all day coming downtown just to make a minor court appearance, or can they attend, by video and take care of their court matters much more efficiently? On the other hand, sometimes coming in person is important because we are interested in relationships and relationship building and being able to access resources that are housed at the court. So improving the accessibility of hybrid options is important. Establishing processes and accountabilities, finding ways to make sure that things that are working are sort of captured, and that we make good practices and that we're able to continue those practices, so that the policies and processes are established and are maintained, even if the individual actors in particular roles change. Training and professional development. Those of us who work in the court in every role need to have access to ongoing training and education. This is an area where, as I've said, in my formal education, even in my law school education, I did not learn very much about this. And so to give people like me and all players in the system opportunities for ongoing learning is an important sort of success factor that was identified in this report. More integration and collaboration with community service providers. There's a rich Indigenous community here in Toronto and all kinds of amazing organizations doing good work, but they don't always know how to get access to the clients who are going through Gladue Court, and we don't always know how to bring them in. So building up a bit more integration is a goal going forward. Looking at satellite spaces, again, if there are Jasmyn said she meets people where they're at, and I think that is physically true. You go where people are, but also, just in all the other ways, we want to be able to that we're meeting people where they're at and not always expecting people to travel to us, to stretch to us. And so I think satellite spaces may be a way to bridge that. And many people spoke about how important it is to have more Indigenous representation in the courtroom. If we can have more Indigenous judges, lawyers, duty counsel, Crown, paralegals, court staff, that makes the space feel more welcoming and safer for Indigenous clients. So that was the end of our formal presentation, but we wanted to leave some time for questions. I hope that this has, we were challenged in terms of trying to pitch this to people who have a lot of knowledge and maybe people who are brand new. So I hope everyone's at least learned a little something or found it to be useful. But we're happy to maybe take the slide down and hear if there are any questions.
So what we're asking, because there's a lot of attendees, if you have a question, please write it in the chat, and I'm happy to pose it to Jasmyn and Emily. Just while we're waiting to see if any questions come in, I don't see any right now. I just wanted to say I am familiar with the Gladue Court at OCJT on the 9th floor, and if I walk in there, it just feels different. It really is a wonderful court. It looks different, it feels different, and I truly think it's one of the best and most distinct courtrooms in our province. There is a comment in the chat that it was a wonderful presentation, and there was a few people that had to leave, but all of the comments are how enjoyable the presentation was. You certainly gave us a lot of information that is really beneficial, and a lot of stuff that we can all reflect upon for sure. I don't see any questions at all. There is in the chat, there is a link for an evaluation. If people could please just take, it takes less than a minute, I promise. Take a few seconds to fill that out. It really helps the HSJCC team in planning future lunch and learns. More comments. There's no questions, but lots of comments, and comment about how enjoyable the presentation was and how much people learned today. So I think there aren't any questions. There was so much information that you shared. I had some questions going along, but you answered them in the presentation, so I don't have any questions either. So thank you, thank you.
I did see, Patricia, I did see a question in the chat, and actually it's a really important one that I forgot to mention, which was about family court. And we do have a family court worker. It's at 311 Jarvis, where family court is held here in Toronto. And she always gets short shrift because we're always focused on the criminal court workers and forget our family court workers. So we don't currently have a family, we don't have a family lawyer, but we do have a family court worker, and we do have a lawyer who does child protection. So if you have Indigenous clients who are involved in family law matters, I would say send them to ALS, because between the court worker, Gawade Nanang, which, as I say, facilitates Indigenous family court diversion, and our child protection lawyer, either we can assist or we can hopefully point people in the right direction. So I really appreciate that question, because it is sometimes one that gets overlooked.
So that question comes from Donna, and she'd also like to know, do they come out to Oshawa?
Unfortunately, most of the services, some of the services are focused on sort of Toronto courts, just because that's where we have folks in person. As I say, our Gladue services are available at more different courthouses, but our family stuff is mostly here in Toronto. But if someone called in to our intake, to our legal clinic, hopefully we could find them a referral to some services that might be closer at hand.
Thank you. Okay, I don't, one other question. Do you have any French-speaking staff?
Oh, I don't know in the Toronto office that we have any French-speaking office staff, but I can't speak to our other offices. There may be Gladue services that can be provided in French. That's a good question. And if you want to, if you need an answer to that because you're working with someone in particular, please send us an email on our website. There's a general email, and if you send that email, I can try to get you a better answer.
Okay, and there's a question, if you could please share the number for that clinic. that you mentioned?
Sure. So again, our website is a good resource in terms of all of our services. The legal clinic, Aboriginal Legal Services, the main line is 416-408-4041. And we do intake on Mondays and Wednesdays between 10 and 3 and Fridays between 10 and 3.
There's another question in the chat that says there seems to be a lot of similarities between the Gladue court and the mental health court. Do the two courts talk to each other?
That's a good question. I think my best answer would be that I think the program staff speak to each other. So I think that, for example, the court workers are going to know, are going to be in contact with the staff who may be running programs out of the mental health court. I know the bail program would be operating in both of those courts. And so at a frontline level, I think that there is some interaction and dialogue. And then at the justice level, I think that's the case. It's the justices, I think speak and share best practices. We have court committees that meet regularly. And so if there's, some issue that's arising in, for example, Gladue court that is relevant to the mental health court, I think at the justices level, there's dialogue happening.
So there's also a question that does ALS have pamphlets that we can hand out to clients? And Sue kindly responded, yes, there are pamphlets at the Indigenous Learning Center on the first floor at OCJT. Thank you, Sue.
Yeah, thank you.
Okay, and then His Worship asks, for individuals who may have mobility challenges and are unable to attend an intake appointment at ALS, do you have staff who are able to visit a potential client at their home or another accessible location?
Yeah, certainly. I think if phone's an option, we do a lot of intake by phone. And so that would be sort of the first option. But if there's barriers with phone and in person, then I would ask someone to, either reach out by phone or by email or have some way to communicate with us, then we can certainly work to accommodate sort of whatever disabilities, whatever barriers people are experiencing to make sure that they can find out about our services and we can identify whether we can help them or, as you can imagine, we can't help every Indigenous person in Toronto with every legal issue. So we also have a lot of referral services that we do.
Excellent. I think that's all the questions. Emily, Jasmyn, thank you so very much for taking time out of, I'm sure, your very, very busy day to come and speak to us. It's such important information that you shared, and it really does give us an awful lot to think about. Some of those numbers are pretty staggering. So thank you again, Emily. Thank you, Jasmyn. Thank you to everybody that joined us today. Again, if you have a second to just go and fill out the evaluation, we'd really appreciate that. But for all of you who drove in today, please stay safe on those roads, because it's really nasty out there. But thank you again, everybody. And on behalf of everybody at the HSJCC, thank you for joining.
Thank you.
Thank you.